I'll just, yeah, go for it. So feel free to also jump in throughout the session with questions. Probably easiest in the chat, but like also feel free to chime in. So yeah, welcome. So nice to see you all. And um also I am recording this session. I might distribute the recording later. Or I might not. I haven't decided what to do with the recording, but just let everyone know I'm recording. So for those of you who don't know me, hi, I'm Julie. I studied at AUT from 2018 to 2021. I studied law, but I studied communications before then. So my background is I was a journalist and a lecturer in communication studies. And while I was lecturing, I was able to study for free. So I went and did law and then realized law was my calling and yeah, never went back. So I worked in property to start with, and then I found an amazing job at Frontline Law, and we mostly did public law litigation. So I don't know if you heard of the case with the defense workers and the police and the vaccination. So then my firm was the one who did that, and we overturned that based on the Bill of Rights Act. So like I'm really excited to talk about the Bill of Rights Act. I love it. It's so interesting to me. So yeah, super, super stoked. I think this is going to be one of my favorite sessions that I do. So you probably heard before, I'm a full-time mum right now, living in Queensland in Australia. I've got a 6-month-old and a 2-year-old boy. And yeah, they've got a babysitter. They're with their grandfather. So don't worry if you hear them yelling. They're sweet. And in my spare time, I've been selling my study notes. And it started organically. People just emailing me, asking for the notes. And then I put up a website and it kind of exploded across New Zealand. So it's been a lot of fun. I've got one part-time staff member who tutors people as well as helps me with different things. So I'll show you. Ooh, not that. What am I going for? That. Yeah, so this is my website. You've probably seen it if you're here, but yeah, this is where you can buy my study notes. I was top of 13 different papers, including constitutional law and judicial review. And I think I won 2 or 3 prizes for public law. So yeah, my notes are awesome. Definitely wish I could have bought them when I was studying, for sure. Yeah, I just structure them in a very cool way. They're very easy to read. They're very colorful. I use simple language. It took me a long time to think of these formats. So I'm very proud of them. And if you did want to buy some for these papers or for any papers, I've got a discount code for you guys, which is good until midnight tonight, and that's public 10 off. Okay, so that was a little bit about me. The structure of this session, I'm just going to give a bit of an overview first of these papers for about 10 minutes now. And I want to talk about unreasonableness in judicial review, because I feel like that's a really tricky one. Put your hand up or like say something in the chat if the unreasonableness standard is something that you're keen to learn more about. Yeah, I see Gaza, Gina, Bree.
Remind me again what unreasonableness was.
Yes, yep. Okay, yep. I think that answer means yep, we're going over unreasonableness. Yep. So there's 3 grounds of review if you're judicially reviewing, and it's one of the grounds. Yep. Cool. So I'll just go for it. And like I said, feel free to jump in with a question at any time. So I'll share my screen. I find it easier to talk while looking at my notes because then I remember things. So judicial review. Just first of all, the way I took these papers was that I first did constitutional law and I second did judicial review. But I feel like most of you guys will be looking at judicial review now and the Bill of Rights Act. Okay, so we've got three main grounds of review in judicial review. So basically, you've got a government body or a government actor, and they've done something wrong, and you want to sue them. So there are three ways you can sue them. This is probably really obvious. Just the first is illegality. So the government actor has done something that's illegal. Let's say it is like an Auckland council member, and there's an empowering statute which says this Auckland council member is allowed to change the color of rubbish bins within Auckland. All right, so he's got this in Parliament's gone through, talked about it all, and he's got this piece of law which says he can change the color of rubbish bins. Next minute, he's gone ahead and not just changed the color of the rubbish bins, but changed the days of the rubbish bin collection, changed the amount that rubbish bags cost. So someone in the public could be like, actually, I'm going to sue you because that's illegal. So that's the easiest ground of review to sue the government actor on. It's just, here was your statute and here's what you were allowed to do, and you've done something different. So that's really, in a nutshell, illegality. Also, I'm saying government actor a lot, but non-government actors can potentially be judicially reviewed if they have like a public-facing role. So, for example, when I was working in litigation, I was doing some work for a guy who got kicked out of a tennis club because he didn't have a vaccination. So I thought this club was amenable or like able to be judicially reviewed because it was a public-facing club and it had, it has members. It's not just like a private organization. All right.
Would judges be another one?
Judges?
Like the actions of a judge in a court, could that be held to judicial review?
No, that is such a good question, though. That stumped me for so long because it's really hard to, they're public-facing sort of people.
Yeah, that's why I asked the question.
Exactly. No, it's a great question, and I think it stumped me for weeks, but they're not amenable to judicial review.
Why?
Because, let me try and frame this answer correctly.
Yeah, you're all good.
I need to go back and explain the history or the purpose of judicial review. So in governments, you have the three, in New Zealand at least, you have the three main powers. So you've got the government.
Yes, you have you have Parliament and the Crown.
Yeah, okay, I'm just going to mute you so I can keep talking. Sorry. Okay, so you've got you've got Parliament, you've got the executive, and you've got the judiciary. So within the judiciary, you've got your own form of review, so you can appeal things. There's a whole system of appeal within the judiciary. Outside, what we're looking at with judicial review is the actions of the executive, mainly in the form of lower bodies. So we're looking at holding them accountable by using the judicial system. So the judicial system. Oh, someone's there, Hugh. The judicial system is not the subject of what we're reviewing. It's the vehicle to review the public-facing decisions made by public bodies or government bodies. So, in America, I feel like we all know American judicial review better than New Zealand. In movies where they're like, this is unconstitutional, I'm going to sue. It's like they're judicially reviewing the government decision because it's against the Constitution, and that's the way the American system works. So then the judges are stepping in to regulate the government. So it's a way of powers regulating each other. It's the judiciary regulating the government. Cool. So we've got judicial, we've got illegality, the best one to sue. Like if you can sue on illegality, that's the best because it's very black and white. It's like you did something illegally, you're done. The next one is procedural fairness. So that's like if you didn't follow a fair procedure when doing something to someone, then it might be a ground to get that decision overturned. So this is where you're thinking of things like natural justice and like it's fair to give someone a hearing before, ruling against them. It's fair to give them notice of what they've been doing. So that is, just check my time. Yeah, that is procedural fairness. And the third ground, which is a little bit more controversial and tricky, is unreasonableness. And unreasonableness stumped me, and it stumps a lot of people because here's why. The actual state of the law is not clear. So as a student, you're going through and you're trying to find the law, and you're like, oh my God, I don't get it because I can't figure this out because it seems so unclear. And actually, it is unclear. So if you're finding it unclear, you're right. I nearly did my honors on how unclear unreasonableness is. And if you read different cases, judges are all trying to figure out in New Zealand what the standard is. So I should go back before explaining the micro. We'll look at the macro. Unreasonableness is the third ground of review, which means you can sue a body based on the fact that their decision was unreasonable. So what does unreasonable mean? In some cases, it means irrationality. Like the judges so don't want to get involved that they're going to say the only way we're going to overturn this decision because it was unreasonable is because we're going to say it has to have been irrational. Like no logical person could ever made that decision ever. It's just so ridiculous. So that's one side of the coin. And that's where you'll hear this Wednesbury approach. So judges are more inclined to take this Wednesbury approach if the person who made the decision, which is being judicially reviewed, is an elected body. Because we've got these government actors, right? And the judges are saying like, whoa, we weren't elected. These guys were actually democratically elected. Like, we don't want to get involved and make their decision for them. It's pretty undemocratic because we're basically overstepping that person's area and being like, we don't like your decision. We think you're wrong. So we're going to come in and say you're unreasonable. So yeah, if there's a elected body, they're going to be more likely to stay away. And the term stay away, it's deferential. It's what's said in judicial review. So you've got that end of the coin. And then on the other end of the spectrum, you've got cases like Kim. So Kim is pretty recent. It was decided. So it's a Court of Appeal, and Chief Justice Wynne-Coleman was still in the Court of Appeal at this time. So I think it was like 2016. So in that case, there was a Chinese man they were trying to extradite him back to China. And if he went back, he would have been executed. And the public body made the decision to send him back. And basically, the current Chief Justice said, there is a fundamental human right at stake here. So we're going to get involved. And we're going to say that your decision was unreasonable. And they ordered the body to go back and make the decision again. So what you've got is this term called variable intensity of review. And what that means is, under unreasonableness, the courts, they don't really know what they're doing, but if you go and try and kind of look through what they're doing, we can say if a human right is at stake, then they're more likely to get involved. If there's no human right at stake and the decision was made from a public body, they're more likely to not get involved when it comes to unreasonableness. Okay. Yeah. Sorry, I just saw your chat in your comment in the chat, Ivan. Yes, that's a good way to put it. Yep. All right. So that was a quick overview of unreasonableness. Does anyone have any questions before we move on to the problem question? The Kim case. Kim and Kim Court of Appeal. I'm just Googling it. I don't know. It's called Kim, but I can't remember the
Kim v. Minister of Justice.
That sounds like it. Thank you. Thank you to whoever that was. All right. Any other questions? Cool. I think we can move on to the problem question. So, did everyone have a chance to read the problem question before jumping in? Yeah, Gaza did. Nice. Yep, Rachel did. All right, I'll share my screen again. And okay, go to the problem question. So very quickly, this problem question is about an act of parliament banning people from going into war zones. So it's like you can only go into war zones if you're a journalist or a humanitarian worker or related to someone living in that area. And then this guy, Francis, he goes to Syria, which is one of the affected war zones, and he says he's a journalist. So there's a bit of stuff saying that yes, he was going to do some news gathering activities, but the Crown doesn't really think so. So what they're arguing about here is Francis is saying you should read this section, and it should only require him on the balance of probabilities to benefit from, hold on, I phrased that wrong. So we're talking about standards of proof here, and he's saying that because it's not clear what standard of proof it needs to be shown that he was a journalist or a humanitarian worker or whatever, he's saying that he just needs to raise a reasonable doubt. So he's saying this is like a criminal section, and all he needs to do is raise a reasonable doubt, and then he's off the hook. And the Crown is like, no, this is a civil section, and you need to prove on the balance of probabilities that this defense, I guess you'd say, applies to you. So he's like, no, I just need to prove that there's a doubt, and then this should apply to me. So the first question is, would this infringement of Section 25C be justified? And Section 25C is in the Bill of Rights Act, and that is everyone who is charged with an offence has, in relation to the determination of the charge, the following minimum rights: the right to be presumed innocent until proven guilty. So if he has to prove on a balance of probabilities that he was a journalist he's saying he's not innocent till proven guilty. He's guilty, and he needs to prove he was innocent. But if he only needs to raise reasonable doubt, then he's saying he's innocent till proven guilty. All right. I see we have a question. Rachel, go for it.
Thanks. Just taking it back to basics, and excuse me if I come across really dumb. When it says balance of probabilities, does that mean that it's more likely than not that his Francis's story is true?
Yes, and that's a really
balance of probabilities.
Yeah, that's a great question. So yes, it'll be proving on the balance of probabilities that he was a journalist engaged in news gathering. So that's a good question. It's a criminal section, and in some criminal can be weird because you've got the beyond all reasonable doubt standard, but then to have some different defenses apply to you, there's two other standards that come into play. So one standard is you just have to raise a doubt that exists, and then that defense will apply to you. And another one is you have to prove the defense applies to you. So
who is the burden of proof in the burden of proof to prove that? Is that on Francis or the Crown?
Yeah, so the burden of proof, if the Crown's interpretation is correct, it would be on Francis to prove he was a journalist. So it's on the Crown to prove he was a resident committing this offence, but it would be on Francis to prove on a balance of probabilities that he was a journalist. Okay. So a bit tricky, especially if you haven't done criminal law yet. But so the question is, would this infringement be justified? Does anyone know where you would start to decide whether this infringement of the Bill of Rights Act is a justified infringement?
I would try and raise whether or not, or who owes the burden of proof. I'd try and figure that out first.
Yep. Ascertain the purpose of the act. R and Hansen. Yes. Yep. Section 5, first question. Does the limit achieve a sufficiently important objective? Yes, you guys are all onto it.
You've got to determine whether that limiting is reasonable, bringing back that reasonable argument.
Yes, exactly. Yep. Great. Yep, you guys are onto it. I'm going to go back to screen sharing and go to, yeah, you guys look great. Ivan, yep. Oh.
Yeah, I was just wondering, should we look at that part where it talks about the Prime Minister designates what a terrorism area is in terms of that Muldoon case? I think it was Muldoon. And it's one of the British cases as well, where it's supposed to be Parliament making these decisions and not the PM unilaterally. Is there any angle there for us, or is it just not to worry about?
Let me think. Fitzgerald and the Muldoon.
Fitzgerald, that's one, yeah.
I read the case. I think Fitzgerald and Muldoon was more about
more about parliamentary stuff, and Muldoon wanted to introduce something and got in and did it straight away without going through the judicial review of Parliament and blah 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 blah.
Yeah, so it was it's about that's right, Gaza. Yeah, it's like Muldoon said publicly, this law will come into play. You can act as if there's this law, and then he got sued, and it's like, no, you as the executive can't just announce a law. It has to go through Parliament. So good thinking with government, but I would say not relevant. Where I would start with this one is, so you've got your section 456, Holy Trinity of the Bill of Rights Act. So when the Bill of Rights Act came out in 1990, there was no explanation of how the courts should interpret secondary pieces of legislation or whatever with the Bill of Rights. So the courts have had to figure it out on their own. And what they've come to is this holy trinity of 4, 5, and 6. So basically Section 4 is saying that no acts of parliament can be judicially reviewed. So this is where we're different to America. So in America, it's this law is illegal because it's unconstitutional. So the judges are above the government because the judges can get rid of the government's law if it's unconstitutional. So in America, Constitution is supreme. But in New Zealand, if an act of parliament is against our Bill of Rights Act, the courts can't get rid of it because parliament is on top. So all the courts can do is make a declaration of inconsistency, which is literally at the bottom of a case, a small paragraph of text, which is we declare that this is inconsistent with the rights affirmed in the Bill of Rights Act. So it's a very weak form of judicial review in New Zealand. I see Gaza has a question. Yes, go for it.
This is probably down to a personal opinion, but why can't the judges just strike down the rule? If it goes against the Bill of Rights, and if the Bill of Rights are God-given basic rights, then why can't they do that?
Because it says in the Act that they can't. Because it says in Section 4 that they can't.
Yeah, and that's, like I said, it comes to a personal opinion of me,
whether that's right or not.
It's a bit dumb to have that in there.
Yeah, it's a whole political question, and the Jeffrey Palmer couldn't get it across the line to be a stronger form of judicial review because we come from the English system where Parliament is supreme. So there's arguments for and against because Parliament's elected, so it's arguably more democratic than judges. But as a lawyer, I err on the side of give judges more power because we're such reasonable people as lawyers and we know best. But that's just my opinion. I agree with you, Gaza. Yeah. So that's Section 4, and then we've got Section 5. So Section 5 is the subject to Section 4. The rights affirmed in the Bill of Rights Act can be limited as can be demonstrably justified in a free and democratic society. So basically yes, we all have our rights affirmed in the Bill of Rights Act, but these can be limited as reasonable people would limit them, basically. So then you've got your Section 6, which is at the interpretation. If you can interpret a statute consistently with the Bill of Rights Act, you should, because it's more rights friendly. So basically from this 4, 5, and 6, the judges have figured out a test, which someone mentioned, New Health. Yep, you can find the test in the New Health case. So what we've got is 1, 2, 3, step 1, step 2, step 3. Within step 3, there's a test inside a test. I always think the movie Inception. You got a test and a test. So within step 3, there's a 4-step test. Then you step out and you go back to step 4, 5, and 6. Oh no, someone said Hansen, didn't they? Yeah, the Hansen test as well, where you can find it. So basically, let's go through this test together, applying our scenario. So step 1 of the test is, does the statute give the authority the right to do what they want to do? So that is what someone said. Let me think. Molly, love. First question, does the limit achieve this? Oh, no, not quite. That comes later. Yeah, so Charlotte, ascertain the purpose of the act. Yeah, it's basically that. So step 1, does the statute give the authority the right to do what they want to do? Basically, can we strike this whole argument down based on illegality, or do we need to keep going? Because if the statute doesn't give the authority the right to do what they want to do, we can just say it's illegal. We can judicially review it there and it's done. So let's look at our problem question. What do you guys think? Is there a problem? Or does it give, can the Crown do what they're doing, which is like charge him under Section 3 of this Terrorism Act? It's obvious, don't overthink it. Yep, I can see Rachel nodding. Yep, yep. We'll move on because I don't want to dwell on ones that are obvious. Yep, they can. And if you've got a problem question, whoops, just put my tea. If you've got a problem question, it's probably going to be a yes because they don't want you to stop at step 1. But if it does stop at step 1, just keep doing all the other steps just for completeness. Okay, step 2 is, does what the authority wants to do conflict with a right in the Bill of Rights Act? So do we have a prima facie or on the face of it inconsistency with one of the rights affirmed in the Bill of Rights Act? And I will check. Yes, yes, yes. Yep, sweet. Yep, we do. It's section 25C. Done, easy. Now let's go to step 3 where we've got our inception test in a test. So if yes to the above, is the breach of the Bill of Rights Act a justified limit in our free and democratic society? So that's the section 5. And there's this test from Canada. I'm half Canadian, so woohoo. And it's the Oakes test. So this mini test says, yes, the right being affirmed is justifiably limited if it's achieving an important objective, if it's rationally connected with but who are you? Can you okay. If it's rationally connected with its purpose, if it's the least restrictive way of achieving that thing it's trying to achieve, and if it is proportionate to the objective it's trying to achieve. Okay, Gaza, yes.
Sorry, I just dropped out because of the internet. Can you quickly repeat everything that was... It was like the New Health in South Taranaki thing, like that test or whatever test we were going over.
Okay, I'll just go very quickly.
Okay.
So we've got if there's a question where you need to try and strike down a act of Parliament or a piece of secondary legislation, you apply the test, which you can find in New Health or Hansen, and that's how to use the Bill of Rights Act. So we're on Oakes test. So let's apply the Oakes test to our scenario. So step 1 of the Oakes test is the purpose of the act sufficiently important to justify limiting that right? So what does everyone think? We've got a thumbs up. Yeah, do we think it's important to keep people out of terrorist countries with terrorism? Yep, we've got, yep, that's pretty good. Yep, Gina, yep. Yeah, it's pretty important for national security and stuff. Yes, yep, sweet. So that one would pass. I think so too. We've got a rational connection. So is the limiting measure rationally connected? So is trying to like stop terrorism and like kind of keep New Zealand safe, is that linked to not letting New Zealand residents travel to terrorism affected war zones? We've got a thumbs up. Yep. Yep, we've got Jasmine thumbs up. Yep. Cool. Yep, I think so. That's not too controversial. Seems connected. Then we've got, is it the least restrictive means possible? This is where you can get into a few different arguments. So is there another way that we could protect New Zealand that's not restricting people's right to travel so much?
I could venture an opinion that the government's essentially saying that it's only okay to fight in a war if they approve it. I mean, I personally think it's a bit over the top.
Okay, yep. Yep, so we've got a bit too much government control. Maybe there's another way to protect New Zealand while letting people travel. Yep. Anyone else?
Maybe let them just go at their own discretion. I was going to say it's your own discretion.
Yep.
That kind of thing. Like, just if you want to go there, go there. It's not our fault if you get killed or blown up or whatever. You ultimately chose to go there.
Yep. Yep. That's one argument. Yep. Too restrictive. Citizens can do as they please within reason. Yes, the problem is that they can't stop citizens' residents coming back. Yeah, that's a good one, Tanya. Yep. And also, if something happens, then the New Zealand government will have to put in money to try and rescue that person or negotiate with terrorists. So it's like putting a burden on the community potentially. Yeah, good arguments. I think no necessary like right or wrong here. Just good to discuss. And step 4 is the limit proportionate to the importance of the objective? So is it a really important objective that we're trying to achieve here, national security, and does that justify this intense limitation? We got a 50-50.
Can you repeat the question? Sorry.
Yep. So is the limitation of the right in proportion to the objective that's trying to be achieved? So I'm guessing it's like national security, keeping New Zealanders safe, keeping New Zealand information safe. Is this proportionate to stopping people from traveling? We've got Tanya. You can probably argue either way. I'd say it's justified in terms of national security. Yep, I probably agree with you. Rachel, do you have your hand up?
Yeah, I just was going to say we don't know the purpose of that act, whether it is national security or whether they're just trying to look out for the safety of New Zealanders. So I guess it would depend. If it was national security, then definitely could be a necessity thing. If it's national security, then like everyone said, it's at your own risk.
Yeah. Yeah, good point. Except like, yeah, it could probably be seen as both personal security and national security. But yeah, it would be good if we could read the purpose.
Because if it's personal security, where do they draw the line? I mean, there's lots of dangerous countries.
Yeah.
Australia's got dangerous spiders and snakes. Are they going to stop us going there?
Yeah, fair. Yeah. So there's like the floodgates sort of argument. Yep.
Yeah.
Yep. Cool. Yeah, really good thinking. All right, I will move on. So we've done our discussion in Oaks. So we've got step 1, 2, 3, mini test within 3. Stepping out of 3, we've got step 4. That's if this, on the face of it, inconsistency is a justified limit. So like if the Oaks test wins, then we can stop arguing here. So like, yes, this is a justified limit in our free and democratic society, so let's just let it go. But even if you, in your exam, you think it is a justified limit, just keep going through the steps so they know you know everything. So if it's not a justified limit, and like what Ivan was saying, or Tanya, and we don't think it's proportionate, we don't think it's the least restrictive means, you can go to step 5, and that's, can this interpretation be given a more rights-friendly interpretation? And that's your section 6. So can our statute be given a more rights-friendly interpretation than what the Crown is arguing?
Potentially.
Mm-hmm.
Like we've been saying, it could be, we could just say, use the whole like discretion rule.
Mm-hmm. Yeah. And Tanya, if the burden of proof shifts, yes. So if the perhaps the most rights-friendly interpretation is Francis just being able to raise reasonable doubt that he was a journalist, and then that counting as the defense, and then that defense applying to him. That's probably the most rights-friendly way to interpret it. Although the judge said she thinks she's inclined to think the natural meaning of the act will require to prove on the balance of probabilities. So you've got that. That's what she thinks is the most natural way to read it. But if we're looking at section 6, then we should probably, argue that it could be given a more rights-friendly interpretation. So finally, after that, we've got step 6. And step 6 is, if all else fails, the courts must apply the legislation. So that's your section 4, and that's the stuff we're talking about, that Parliament's on top and the courts come second. So to give you a quick rundown. Wait, does anyone have any questions?
Can I say I don't think it's worded very well. I mean, it's inviting you to raise, his argument is to raise a reasonable doubt about an exception, which is very unusual. It would usually be raise a reasonable doubt about the actual offence. So it's kind of flipping that on its head. So I mean, how do you raise a reasonable doubt about that exception? Well, I think what it's essentially saying is he'd have to establish it to a threshold, whatever that threshold might be.
Have you studied criminal yet?
In the past, I have.
Oh, yeah. I mean, this is not. This happens in criminal statutes, so there are different offences that have been interpreted as you need to just raise a reasonable doubt as to whether that counts, and then that defence will apply. But there are some that where you need to prove on the balance of probabilities. So, like, you've got your statutory regulatory offences where you might have to prove on the balance of probabilities that a defence applies. Anyway, it's kind of off topic, but I hear you. It is worded poorly, but it happens in criminal law. There's different standards of proof, and it's really tricky. Okay, so I'll just quickly run through the test with a different example very quickly, just so you can kind of get a gist of how you might apply, how you might go about an exam question. So this New Health case, it's pretty recent. I think it's 2017, and it's about, in South Taranaki, some people were trying to argue that putting fluoride in water is against the Bill of Rights Act, and for medicating. They're saying it's medicating people. So the court said, it went all the way to the Supreme Court, and the court said, yep, the statute gives the council the authority to fluoridate water. They said, yes, there is a prima facie inconsistency with the Bill of Rights Act, because fluoride could be seen as a medical treatment for teeth, to strengthen teeth. So yes and yes. They looked at the UGS test and they said, yes, does the limiting measure serve a purpose that's important? Yeah, it's trying to prevent tooth decay, which is important, especially in lower socioeconomic areas where they might not always brush their teeth. People might not always brush their teeth. So it's really important that at least in the water, there's some fluoride. Is there a rational connection? Yes, because preventing tooth decay and fluoridation, they could find that it was rationally connected. Like they went into all the science and this and this and this and this, but they're like, yeah, it's connected. There's like controversy around fluoride, but they found it was connected. Is it the least restrictive means possible? They said yes, because there are other options, like let's say adding fluoride to fast food, but they're not fully addressing the issue. So they thought this was the best way to help tooth decay that they could think of. And was it proportionate? They thought the amount of fluoride being added was normal and consistent with like levels in other countries and even levels naturally occurring in other countries. So they thought it was a proportionate limit of the rights. So they stopped it there. All right. So that was the problem question. I'm gonna like hold an awkward silence for like 15 seconds and see if anyone has any questions about this.
So in the exam, you may potentially have to repeat yourself a bunch stating the obvious, even though it was stated 10 million paragraphs ago.
What do you mean? Why would you have to repeat yourself?
I mean, so you would state, yes, the section is inconsistent, blah, 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 blah. But in terms of the Oakes test, you would have to repeat yourself a lot.
I don't think it's necessarily repetitive because you probably get one problem question. But yeah, you have to go through the whole test and don't stop at just go through step 1 to 6, show them you know what you're talking about. All right, Sophia.
So here would be a good place to talk about parliamentary sovereignty and separation of powers. With judicial review, even if it finds there's a justified limit, it has to go with what Parliament says because Parliament's supreme.
Yep, that's right. Yep. These two areas are for sure connected. I would say if you're given a problem question, should you talk about parliamentary supremacy? Yep, I think it comes up. I feel like a more in-depth discussion about like separation of powers and parliamentary sovereignty is like well suited to a sort of essay question. But for sure, this comes up because section 4 says basically Parliament is supreme. So if your act is inconsistent, then you can't strike it down. But you raise a good point, which is that so you've got your acts of Parliament and then you've got your secondary legislation. So you've got your regulations. An example is like there's the Pandemic Act, which says the Minister of Health is allowed to like do A, B, C, D, E, F, G if there's a pandemic. And then when COVID happened, the Minister of Health made a different regulation which stopped certain people from getting vaccinated. So you can get rid of secondary legislation. That's because it's not Parliament that made the law, it's one of the lower people. So in the case that my firm did about the Defence Force and the police workers not getting vaccinated, so they got fired or like removed from the service because they were unvaccinated against COVID. And then my firm argued that this was inconsistent with the Bill of Rights Act, the right, like a whole bunch of different rights. And it's basically because the statute said, like, we're just trying to keep people from, like, we're trying to keep consistency in the forces. So like if they're more likely to get COVID, then we will have a big gap and there'll be heaps of people unemployed. So there won't be like enough police workers. That was the justification in the statute. And like we showed like there were only 100 people. It was not going to have a big difference, blah, blah, blah. So the court said the rights being affected were massive and the justification was not great. So we actually got rid of that whole regulation and all those workers went back to work very slowly, and it took a long time, but they all were legally allowed to go back to work after that.
Somewhat remember that. This is going to sound like, I think I think COVID had a lot, and all the vaccine stuff had a lot of Bill of Rights stuff that had been.
Yeah. It definitely did. And my firm, like, we did this big case, and then we became like the vaccine firm. So we were like, okay, let's just go for it. So it worked well. So moving on, we've got like a couple minutes left. Does anyone have any questions about public law in general? Okay, I've got some questions in the chat I'll deal with. I'll first answer Maggie's questions. Do you have tips in terms of how to structure problem questions? I have. Yes, because I did a tutorial like a while ago and this question kept coming up. So I actually made a guide on how to answer legal problem questions. Let me find it on my computer and show you. Yes, so if you go to my website, how to structure answers to legal problem questions, I've made a full guide and it has a model answer. The model answer is from a torts question. It's based off a question I got 100% in, but it will apply to anything. So it's just like a generic model answer. But yeah, this breaks down exactly how the process I went through to answer problem questions. And we've got Stella. Do you know any other cases successful in arguing the Bill of Rights Act? And is for argument only applicable to primary legislation? Very good questions. So I'll start with two because I've kind of gone over that. But yeah, you can argue the Bill of Rights. So the Bill of Rights Act only applies to public decisions. So you can't argue, you can't sue your employer under the Bill of Rights Act. And that's because I think it's section 3. Yeah. So section 3 explains that it's only applicable to the legislative, the executive, or the judicial branches of government, or any person performing a public function. So if your employer is breaching one of your rights, you can go for the Human Rights Act, you can go for the Employment Relations Act, but you can't do a Bill of Rights Act argument. So it's only for public-facing people, bodies. So that's a really good question. And then question 1 is, do you know of any other cases that were successful in arguing Bora? Let me just check. Whoa. Hansen. Yep, Hansen. That was the weed case. I believe they applied a declaration of inconsistency. I've got a note, like, did they? I can't remember. So I need to double check that. But yeah, Hansen. So you've got New Health. No, they lost. You got Hansen. If you check out, I'll write the oh my goodness, the case citation for the case that we did, if you want to check it out, where they won with the Bill of Rights Act argument. What was his name? I literally had coffee with him.
Was it the weed under the dressing gown thing?
No, I'm thinking of a different one, but what's that case? That might be another one.
Oh, I can't remember. We did it in torts with like privacy and shit.
Might
Trying to
not be.
remember what it was.
Yes, someone said Taylor and Attorney General. Who was that? Thank you, Emma. Yes, they made a formal declaration that prisoners, yeah, that's a really important one. The prisoners' voting case. So prisoners not being able to vote was against that bill of a right affirmed in the Bill of Rights Act. Yes, thank you, Emma. I can see a few people are leaving. I just want to quickly say before you leave, if you did enjoy the session, would you mind writing a comment in the chat? And I would like to use your first name and your comment and just use it as a testimonial for like to promote upcoming webinars that I have. Yeah, I'll be grateful if you would do that. But we're not finished just yet, people. So we'll just do a couple more minutes of questions. Actually, like one more question probably, and then I'll wrap up. Thanks, Jessica. Does anyone have one more question before we wind down? No. All right. Yeah. Thank you. Thank you all so much for coming. I had a blast. I love talking about this sort of stuff. So thank you. I hope it provided some clarity on the subjects, and yeah, just nice to meet you all. Nice to see a whole bunch of different students doing such amazing stuff, working, busy being a mum. I hope your study's going well. If you do want to get any of my guides or my notes, I'm just going to upload a document in the chat, which you can download